Okay, we'll call this meeting to order. Please rise for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, good evening, everyone. Our first item is to recognize the 60th anniversary of the Hideaway Swim Club. Bill, you want to start us off?
Oh, certainly. Many of us know the Hideaway Swim Club in Horsham is celebrating their 60th anniversary this year. They have been around for a long time, of course, but to many families, I guess thousands of Horsham families have been through over the 60 years, have been members. And it's a unique swim club in that it has a lot more to offer than just a swimming pool, and I don't want to steal anyone's thunder out there. But it's the way it works is a family buys a bond and becomes a part owner of the swim club. So and everyone volunteers to do maintenance, snack stand. Everyone comes together to keep it alive, and it's another hidden treasure of Horsham. You drive up and down County Line Road and you probably see the sign, but until you drive back there and you get out of your car and you walk around, I think it's 16 acres, I think, total. 33 acres. But you don't even know County Line Road's 500 feet away. So they're here tonight. There's a group here tonight, and we just want to say thank you. Thank you for all that you do for the swim club. Thank you all that you do for the membership and for the residents of Horsham and maintaining and keeping the swim club alive.
Bill, anyone down there want to come up and talk to us a little bit about what you do down there?
Well, first, thank you for having us. I'm here with other members of the board over at Hideaway. As was stated, we are privately owned. We have 350 bonded families that really enjoy their summer. We kind of call it our hidden gem, our home away from home. And it is more than just the pool. We have tennis courts, an area for the kids to play basketball. Pickleball is making its way to Hideaway. We do have a place to play a little bit of golf. The kids enjoy the snack stand and all the candy that is available. So it is really a great place. I kind of look at it as it's a way for a lot of us to disconnect. You kind of go back in time and you're just there enjoying company, enjoying the pool, socializing. The kids are having a grand old time and they're not connected to their devices, which nowadays is really just fabulous. So thank you for your support. We really enjoy being part of the community. We have open bonds if you know of anybody interested. We're always looking for new families to join. We have members who have been there for decades, and it's fabulous to see all the generations come together. So thanks again.
How many memberships do you have? How many bond holders?
Oh, I didn't check our recent number, but I would estimate around 300 right now.
Great.
Yeah, absolutely.
So, Bill, perhaps, I'm not sure if we can or not, but would it be appropriate to have something put on our website announcing their anniversary and the fact that they are still looking for new families?
Yes, absolutely. Social media and the website would definitely give them a plug and try to encourage residents to become members.
That'd be much appreciated. Thank you.
Absolutely. So we do have a proclamation for you this evening, and it states as follows. In 1961, Herb Barringer and other residents of the Butternut Drive neighborhood decided they would like a community pool. A group of neighbors solicited memberships, sought a loan, and purchased it says 16 acres, but I understand it's 33. When we get that.
16 in 1961.
For $25,000. Hideaway Swim Club officially opened its doors in 1962 with just a swimming pool and a boat and a bathhouse. Over time, the private self-sustaining swim club expanded to 2 pools, tennis, basketball, shuffleboard, and beach volleyball courts, and a 9-hole chip and putt golf course, with pickleball soon to come. Located on County Line Road in Horsham, Hideaway Swim Club is home to the Hideaway Hurricanes swim and dive team, and offers opportunities for all members, including tennis lessons, pop-up fitness classes, craft markets, and trivia nights. The swim club also supports community members in need through collection events for organizations such as Toys R Tots. For the last 60 years, Hideaway Swim Club has served as a valuable resource to the Horsham Township community, and we are fortunate to have their positive impact in our township. We are honored to recognize you and congratulate you on your 60th anniversary and wish you many, many more years. Thank you very much.
Okay, if all the board members want to come around the Diaz, we're going to stand against the stone wall here.
One, two, three. Okay, next item is an opportunity for questions and comments from the public. Anybody? Yes, sir. You'll come up to the microphone and state your name and address, please, for the minutes.
Good evening, ladies and gentlemen. I have kind of a loud voice, I'll stand.
No, you have to really get
Okay.
close,
All
sorry.
right, how's that?
Yeah, it's perfect.
My name is Brendan McVeigh. My wife Teresa and I are residents of Horsham since December of 2018. And this is a letter that I wrote to the township board members 2 years ago, in March of 2020. And it's still pertinent today. My wife and I would like to petition the board, request from the board to add a noise ordinance to the next township meeting. If there is already a noise ordinance on the books, if there's a way we can add a subsection or another section to it of disturbing the peace or harassment, that would be great. We have been having an issue with one neighbor whose house is catty-cornered from ours. We live on Windmere Drive. She lives on Cheswick. This individual plays music at a very loud volume at all times of the day and night. It usually starts around 9, 10 a.m., and most days it will continue until 10, 11 p.m. On weekends, on occasion, the music has been played until 1 a.m., where we have been able to hear it with our windows and doors open, leading to our backyard. The situation has gotten to the point where we are not able to have said windows and doors open or even enjoy our evening deck and backyard area because of the volume of this music. Both my wife and I work from home, and we have had to take our weekly conference calls in our cars because the music is heard throughout the house. I would like to note that we do have social media documentation, pictures of this speaker being aimed towards our backyard and home. Bill, I emailed that to you before the meeting. We also have this commentary on social media platform about this situation. Just a few of her remarks are as follows. Rainy night. My neighbors will be happy there is no loud music tonight. I don't expect quiet after 9 p.m. I don't live in Florida. I am not old. Let them call the cops. And finally, if they do not like it, they can move. We will be more than happy to present this documentation to others if you so choose. She has been asked to lower it on multiple occasions by ourselves and other neighbors, some with babies, small children, and neighbors who sleep during the day because they work overnight. And she continues to play it at a level where we can hear it in our houses. Her demeanor to us approaching her about this back in 2020, we have not done it anymore because of her demeanor, has been extremely rude, thoughtless, selfish, and indifferent to the feelings of the people who live here. I've seen a lot of people posting on the Horsham Facebook page about a noise ordinance being voted on in township meetings, and I do not understand why the township hasn't considered this in the past. There seems to be posts almost weekly, if not more, on this Horsham page regarding this very important issue, and it is our hope that this letter and me being here will help bring a noise ordinance to the next township meeting. We very much appreciate you taking the time to consider our noise ordinance request, as well as reading our letter. My wife and I can be available to discuss this further with you if you so wish. Our contact information will be at the bottom of this letter.
I'm going to take a stab at this, but I may have to defer to Mary. From my understanding is, if we pass a noise ordinance, which we do not have, they're not enforceable. The courts have ruled that they're not enforceable. So our hands are a little bit tied in this case. Am I stating this correct, Mayor?
Close to correct. It's all.
Close is not good enough. Maybe you can get it more accurate for me.
Noise ordinances are notoriously difficult to enforce because I think there's probably noise regulations in our zoning ordinance, and the enforcement procedure in the zoning ordinance is difficult. It means that somebody who, like the zoning enforcement people, work from 8:30 to 4:30, and So when you have terrible problems on the weekends, they're not here for you to call. So it's got to be an departmental solution to noise problems like the one you're experiencing. And the only thing that I can offer you is that staff will talk about it between the code enforcement department, the police department, and just try and find the best solution to this kind of problem to see if the township.
I don't know.
And I have been in contact with the police on multiple occasions. Lieutenant Larry Bizzacco even came by our house, walked behind the houses on Windmere Drive and could hear it. He knows what I'm talking about, that's probably why he's smiling. I've also been in touch with Jamie, his last name is escaping me.
Franklin.
Franklin, yes. And he has seen the videos, he has seen the documentation. Apparently, the director has been in contact with the chief of police. I don't feel it should have gotten this far. Again, I'm not going to approach this woman again because she basically, on Saturday, there was another altercation where my neighbor, Chris Vesely, has a 1-week-old child. And she's playing music till 9 o'clock at night where they can hear it through their house. And he approaches her and she is cursing him out. She is indignant and I don't know what else to do. Because if I approach her, I know how she's going to react and I don't want tensions to get heated and things to be said where I could be, deemed harassing her. So is there anything that can be done so that we can enjoy the peacefulness of our backyard in Horsham?
That's exactly what we're going to meet and try and figure out the best way to do that.
Okay.
Yep.
Can I get cards from all of you, just if you don't mind?
They're all on the emails are on the website.
Okay.
But I'll schedule a meeting with Chief Fida and Lieutenant Bazamo. Also, Mike Shinton, who is on vacation this week.
Yes.
He's
Yeah,
our
Jamie let
Director
me know
of
that.
Codes.
Yep.
And Jamie. So it'll probably the meeting will happen next week.
Okay.
But we'll all sit down and strategize to see what we can do to help.
Thank you very much. I very much appreciate it. Enjoy your
And
evening.
does Jamie have all your contact information?
Yes, I've
Okay.
emailed him a couple of times, just saying, hey, did you get my documentation? He said yes, and we're going to go further with that.
Okay.
All right.
Well, we'll be in touch with you next week.
Thank you very much.
Well, keep us posted on that, would
Will
you?
do.
Thank you. Anybody else? Okay, next is, we're going to have a conditional use hearing. Council now calls to order a hearing on the conditional use application filed by Aqua Pennsylvania on behalf of Hatboro Borough for a property at 2 Blair Mill Road, which most of us identify as the Hatboro Little League Field. Aqua filed this application in order to install an ion exchange filter system on the property for the removal of PFAS from water supplied by the 2 wells owned by Aqua. They'd be wells number 6 and number 8, located on the property, and for the placement of the utility lines across an unnamed tributary of the Pennypack Creek within the riparian corridor conservation. Notice of tonight's hearing on the application was published as required by law, and it would be appropriate at this point for Mr. Gadea Walker to enter into the records those documents relating to the filing of the application and the public notice of said application.
Okay, the first township exhibit is T-1. It's resolution number 2022-28 of council setting the time and place of the public hearing. T-2 is the letter from the township manager dated July 6, 2022 to the reviewing agencies. Exhibit T-3 is the notice to all property owners within 500 feet of the property, dated July 6, 2022. Exhibit T-4 is the legal notice of the hearing. Exhibit T-5 is the review letter from the Montgomery County Planning Commission, dated July 21st, 2022. Exhibit T-6 is the minutes of the August 1st, 2022 Horsham Planning Commission meeting. Exhibit T-7 is the letter of Gilmore and Associates dated July 25th, 2022. Exhibit T-8 is the Mikulski and Faber review letter dated July 21st, 2022. And And the last exhibit is T-9, which is the review letter of E. Van Rieker dated July 25th, 2022.
Hey, thank you, Bill. I'm sorry, Mayor.
The last exhibit was T-9 or T-10?
9.
Can we add a T-10 and make that the application and the exhibits attached to the application?
Yes.
Thank you.
So if any person present this evening would like party status in this matter, it is necessary to let us know that now. Party status can be granted if you live close enough to the property to be aggrieved by the use proposed. Persons with party status may cross-examine the applicant's witnesses and may present witnesses of their own. Only a party may appeal the decision of council in this matter. If you do not request party status, you will still have an opportunity to express your opinion and tell council whether you would like to see the application granted or denied. Is there anyone here who would like party status? Okay. I'd like to take this opportunity to remind those of you here tonight that this hearing is being transcribed by a court reporter. Therefore, it is necessary that you not speak unless recognized by counsel. If you do speak, please give your name and address prior to making any comment so that she can record attributes to your remarks properly. Going too fast for you? Sorry. I go reading pretty quickly. I note that Attorney Deborah Schultzke is present this evening on behalf of the applicant. Ms. Schultzke, would you like to begin?
Good evening. Again, for the record, Deborah Shulsky with the firm of Riley Riper, Hahn and Colagreco, here on behalf of the applicant, Aqua, Pennsylvania. Also with me this evening is Brendan Kelly on behalf of Aqua and our civil engineer, Roger Phillips. And as the president indicated, we're here tonight for your review of a conditional use with respect to a riparian buffer crossing for utility lines associated with an upgrade of Aqua's existing water treatment facility on property that I'm sure you're all very familiar with, known as the Hapro Little League Fields. I'd like to handle the hearing this evening, if the council has no objection, is do what I call an offer of proof, whereby my witnesses would be sworn in. I would summarize their testimony, they would affirm it as their own, and then obviously be available to answer any direct questions that council would have.
That's no problem, sure.
Okay. And before we get started, I'm going to hand out some pre-marked goodies. I believe all of which, except for two, are redundant with the exhibits that the township submitted.
Thank you.
And if I can just have 1 second, please.
Thanks.
Mind if I take a seat?
Sure.
Okay. So before we get started, I guess we could swear in the witnesses, then I'll summarize each of their testimony. They can affirm each as their own, and then obviously provide any clarification if they feel as though I may have inaccurately described something.
Raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And can you just state your name, please?
Roger Phillips, professional engineer with Gannett Fleming. Brendan Kelly, engineer with Aqua, Pennsylvania.
And the first witness that I would summarize is Brendan Kelly, and he essentially would be a fact witness who would testify to establish standing and also provide some background about Aqua, Pennsylvania. And Mr. Kelly would testify that he's a senior engineer with Aqua and has been employed with Aqua for over 25 years. He would state that he's authorized to appear here this evening and testify on behalf of Aqua. Now, he would further state that Aqua has standing to proceed with this conditional use application by virtue of an easement agreement with the underlying property owner, Hapro Borough Authority. A copy of that easement agreement is marked in your package as Exhibit A2. That easement was granted to Philadelphia Suburban Water Company, which you may recall changed its name to Aqua, Pennsylvania back in 2003. Mr. Kelly would testify that Aqua has an existing presence in Horsham community by virtue of its existing water treatment plant in the township. In addition to its local presence in the suburban Philadelphia area, Aqua is also located in 7 different states. Mr. Kelly would further testify that Aqua is committed to working with the community for this particular application as well as in general, and he has spoken to his immediate adjacent neighbor in this matter. As a result of some of those discussions and some discussions at the last Planning Commission meeting, Aqua has agreed to maintain the trees along the perimeter adjacent to the neighbor to maintain the existing buffer to help shield that property from the baseball field lights in the fall time. And lastly, Mr. Kelly would testify that he was present at the Planning Commission meeting when this matter was reviewed by the Planning Commission, and that the Planning Commission ultimately made a favorable recommendation on the application. Mr. Kelly, would that essentially summarize your testimony, and would you affirm that as your own?
Yes, I do.
Does council have any questions of him, or do you want me to go through? Okay. The second witness I would summarize is Mr. Roger Phillips, who would testify that he's a professional engineer and has a number of years of experience representing both applicants and municipalities, and that he's been accepted as an expert in a number of proceedings before municipal bodies. His CV is marked in your package as Exhibit A3. Now, Mr. Phillips would testify that his office prepared the conditional use plan and a PowerPoint presentation plan, both marked as Exhibits A4 and A5 in your package, and that the plans accurately depict what's being proposed. The property, as you know, contains an existing Little League fields and Aqua's existing water treatment facility. There's an area depicting the existing conditions of the site as they are currently shown on sheet 2 of Exhibit A5. Aqua is proposing an upgrade to its existing facilities consisting of an approximate 1,940 square foot building and associated improvements, including utilities. As you know, conditional use approval is required to permit utility crossings within the riparian corridor district. The utility crossings consist of the construction of a 6-inch raw water main. The location of the utility crossings is within an existing improved area on the property, which consists of gravel, natural stream bank, grass, and some paved walking trail. And sheet 3 of Exhibit A5 shows the location of the riparian buffer and crossing area. Sheet 5 of Exhibit 5 shows a blow-up of the exact location. And as you can see from that sheet, the proposed crossing will be in an area that is already substantially improved on the property. The proposed building that Aqua is constructing is compatible with the surrounding residential area. It will be comprised of brick and has features that will look residential in nature, including a peaked roof, a pitched roof. This is depicted on sheet 6 of Exhibit A5. The building will be surrounded by a secured 6-foot-tall fence. Aqua has agreed to slightly relocate the fence in order to preserve some of the existing trees in that area to help maintain the buffer. And again, that was something that was suggested at the Planning Commission meeting by one of the neighbors. Mr. Brennan also has had discussions with that neighbor directly and believes that he is supportive of this application. Mr. Phillips would also testify that Aqua, in conjunction with this application, is proposing stormwater management facilities that would accommodate these proposed improvements, whereas there's currently no stormwater management on the property to date. Mr. Phillips would further testify that he reviewed the Township Engineer's review letter, the McCluskey Landscape Architect review letter, as well as the Montgomery County Planning Commission review letter, and there's no items or issues in that letter that can't be addressed, and that Aqua has agreed to comply with all those requirements, including a restoration plan. And of course, your Township Engineer will be reviewing and approving the stormwater management plan as well. And lastly, Mr. Phillips would testify that he reviewed all the applicable ordinance standards and that the facility complies with those applicable standards. In addition, the proposed crossing would not adversely affect the health, safety, welfare, or character of the neighborhood, and in fact, it would be an improvement by obviously providing and improving the water facilities in the community. One last item I wanted to note, I'm not sure whether it's part of this application, but We are also, Aqua's also seeking a waiver of the land development process. Again, as I mentioned, the stormwater management, and there'll be a grading plan, and all the permits will be obtained, and that will be reviewed by the township engineer. But they're going to be seeking a waiver from the land development process. And that would essentially summarize Mr. Phillips' testimony. Do you affirm and adopt it as your own?
I do, yes.
Do you have any corrections or additions?
No.
Do you have any questions up here?
I think Ms. Shulsky said it many times, the trees, the buffer. We deal a lot with the residents on Home Road regarding the ball fields, the noise, the lights, the kids. So I think you said you were going to preserve the tree, that buffer between your building and the residents on Home Road. Is that?
We are preserving a number of those trees. I don't want to say that we're preserving every tree, because there are some trees in that area and some of the lower scrub that needs to come down to accommodate the building and the access around the building. But the gentleman that lives, if you look at the exhibit, he would be off the far top left corner. They were the ones that Brennan had met with them in the field, and we had some discussions with them. We had pulled the fence back in there. There were 3 trees that were 24 to 36 inch in diameter, substantial trees. We pulled that fence back substantially so that it doesn't get into the drip line of that tree, and preserves those trees. There are also some trees behind the facility that we're leaving behind the fence. But a lot of the trees on the left side of the facility then would be coming down. And again, there's not a lot of these. Do you have, is the exhibit with the tree survey in there?
Was that for the PowerPoint?
No, it was the other one I sent you.
Is it that one?
No, it's the one I sent you the other day, where we did the survey.
Would you be willing, when you get to the point of construction and to meet out in the field if need be, and if you had to add, 3 or 5 trees, be willing to work with us in the field for a field change?
Sure, and once we get out there, and if the fence can be pulled in a little bit towards the facility, they're certainly willing to do that also.
Okay, thank you.
And the purpose of the trees, Mr. Walker, would be to buffer all of the houses on Home Road, or the additional trees?
Well, the ones that are definitely contiguous to it, but also to give a buffering to that neighborhood from the trees that are lost for the construction of the building.
For purposes of drafting a condition, what you would like to do is replace enough trees so that the neighborhood along Home Road is buffered as they are now from the lights on the Little League field.
Yes.
Thank you, sorry.
Are there going to be any service interruptions while you guys are upgrading the new mains?
No.
Bill, there's the request for a waiver of land development, that comes later?
Yes, sir, that's a different, yes.
We'll back later for that. Okay. Any other questions up here? Okay, this hearing is now closed. Council will render a written decision at our next regular meeting. Thank you.
Okay, thank you very much.
Thank you.
I'll send you, I'll scan everything
Our next item is approval of list of checks. Do we have a motion?
Move to approve the list of checks in all funds in the amount of $259,739.52, and further move to authorize payment of the same.
Moved in second, all in favor? Aye. Opposed? Ayes have it. We have a subdivision land development plan, the McCullough.
This is 342 Whitmer Road. If you're familiar with College Settlement and the Coon Day campsite of Whitmer Road, is right contiguous to that. Also, which everyone's familiar with, is the Horsham Water and Sewer Authority Water Tower. on Whitmer Road. So this is the water tower here. So this lot, this long, narrow lot is 342 Whitmer Road. It's in our R3 zoning district. And what they're proposing a subdivision of 5 lots. And I think it's just slightly over 5 acres, the total 5 acres. It's a by right plan in the sense that they didn't need any variances for zoning issues. And they are here this evening to present their plan. This is a review, and they've requested a preliminary final review. It was reviewed by the Township Planning Commission. Township Planning Commission did recommend preliminary final approval, but tonight they're just in front of you for review.
Good evening. Kristen Pianzio with Hamburg, Rubin, Mullen, Maxwell, and Lupin. It's nice to see you. I have Nick Rose to my right. He's our civil engineer. Dave and Mary McCullough to my left. They are the owners of the property. Mr. Walker stole some of my thunder, but if we could go to the aerial plan for just a minute. I think it's a separate slide,
It's a different slide.
right?
The second one, you might just need to zoom in a little bit.
Oh, you could use,
The right
yeah, you could use that one. Oh,
where the
Oh.
county's better.
Don't ask me to do too many different things.
right there. Okay, so this is the McCullough property here. It's very narrow. It's only 164 feet along Whitmer. It's about 1,300 feet in depth. Next to it is the Muldoon property here. This is like a similar lot of also of 5 acres. Here's the water tower. This is the campground, and here you have the Powerline Trail. I call this the Hallmark development. You know it as something else. Chestnut, is it?
Sussex Court.
Okay. So there's a cul-de-sac bulb here. I guess there was some planning involved, thinking that all this would be developed at one time together. That's not the case. The Muldoons are not interested in developing at this point. So here we are. The single house is here in the front. That is served by an on-site septic system. We are proposing public water and sewer for this property, and that Lot 1 will be connected to sewer. If we go to the site plan now, that'd be helpful. Okay, great. So, as you said, this is Lot 1. The plan is the McCulloughs are going to sell this whole property as one. We envision this house being torn down. Discussion with the Planning Commission was to have the new Lot 1 house take access off our proposed interior road. Right now, there's a driveway out to Whitmer, and we're willing to close that. We are proposing sidewalks along Whitmer. We are not proposing curb or widening. However, there is a decel lane that is proposed as part of our design to get the cars in and out safely. We are proposing this right-of-way. It is a private right-of-way. It does extend all the way to the back of the property. It is 30 feet in width for the right-of-way. The cartway we're proposing is 20 feet. There is 5 feet of clearance on either side of that. We are proposing something in keeping with the neighborhood, meaning no curbs, no sidewalks along that private area. We do have pull-over areas we've discussed with the fire marshal and with staff. This is a turnaround. The fire marshal asked that that be signed, that no one can park there, so that in the event of a fire truck has the ability to turn around in this area. We are proposing a fire hydrant in the front. There's one here along the way to satisfy his concerns as well. We met with staff in June of 2021 to go over this plan. Dave's had numerous conversations with the fire marshal. His concerns seem to be most paramount as far as this private road. We were in front of the Planning Commission. They did recommend approval. They asked us to have that Lot 1 take access off of here. We also talked about the waivers, which they recommended. We have all the review letters from the reviewing agencies, Gilmore, your landscape architect, the County Planning Commission, the fire marshal. We can comply with all those review letters, but for the waivers, which I'll go over with you in a second. And there was a comment in Van's letter and the County Planning Commission about possibly connecting to the power line property here in the back. As you probably know, there's a formal connection to the power line trail down below on Whitmer. That is a public access, and in our discussions with staff, it was determined that that's the place where the public should access the trail. This is going to be a private road. We don't want to introduce private citizens, other citizens along this private road. We do want to leave it to the developer and these homeowners to maybe create their own connection for their use back here, but not put anything on the plan that will entice the public to traverse this private property. I have handed out the review or the waiver letter, and we can go over those items. We do propose a homeowners association that would maintain this private road and the stormwater basins. With that, if it's okay, I'll just go through the protract waiver list, if that's all right. Okay. The first has to do with existing features within 400 feet. We usually request that waiver in exchange for an aerial photograph. That's not new to you guys. The second has to...
Wait. Make sure everybody's okay.
Okay.
All right, now
All right. The second has to do with treating this as both a preliminary and final plan. Again, nothing major going on here. It's only 5 lots, so we thought that that would be suitable as it has in the past with similar applications. Okay, next has to do with the cartway width that I just explained. Your code requires a 50-foot right-of-way with a 30-foot cartway. We're proposing the 30 and 20, but with the 5 feet of clearance on either side. The fire marshal's okay with that, so we've requested that waiver. It also pertains to the widening that we're not doing along Whitmer, but for that decel lane. We are putting that in and putting in sidewalks along Whitmer.
I just have a question on that. So that's going to be pretty tight. So you guys are willing to make sure that a car can continue on Whitmer as a car is turning onto this private road? Because you're trying to reduce the space that's going to be a full deceleration into that street.
Yes. Answer is yes.
And number 4?
Number 4 has to do with the curbing and sidewalk. That's curbing only along Whitmer, but sidewalk and curbing on our interior private road.
No curbing or sidewalk on your proposed road.
Correct.
You're doing sidewalks on Whitmer, but no curb.
Correct.
So that's what we have now, right?
That's down further, yes. Yep, at Sussex Court, just along the frontage, yeah.
And lastly has to do with the street trees along our private road. This is a heavily wooded lot, so we would have to take trees down to plant trees. So there's no room on the upper end in that 5-foot area. And then along this side, the lower side, we have existing trees. We envision the developer doing some landscaping on his own to, pretty it up, but that would require a waiver of the street trees. And I think Kim is okay with that as well, your landscape architect.
How many
Bill.
street trees?
How many are we talking about?
Yeah.
She says existing trees of 4 inches in caliber or greater preserved within 20 feet of curb or road edge may satisfy the street tree count.
I don't think it would be that many, and what I would recommend is that we treat it as a replacement tree. As you know, coming up on a 1-year anniversary of the tornado, and we lost hundreds, maybe thousands of trees in our park system and open space system that we're trying to replace. So if it's not that many trees, if we're talking 22 trees, if they, would want to give them to the township to plant to replace some of the trees we've lost.
Go with that. How about half? 22 is a lot. Since it is a wooded area, we satisfy the trees that are, the idea of the street trees along this private road, and it is private. We want to be sure that the developer puts the money into these lots and the beautification of this property.
It is private, but there's a lot of other waivers that are being granted. I don't think that 11 street trees is going to meet the whole difference. I think 22 is reasonable.
If 22 is required.
That's what the McCluskey in favor letter says, 22 trees are required.
We're very consistent about getting our trees across the board, so it's going to be 20.
22. Okay,
Good try.
all right.
Nobody's won that battle yet, but that was a good try.
I have to do something here, right, to earn my keep?
Well, you got 4 out of 5.
Okay. And that's it.
I have a comment or a question. The turnaround that the fire marshal approved said that there's going to be signage for no parking.
Yes.
Would you consider working with the fire marshal to make that larger so that if a car parks back there, a fire truck can still turn around? And the reason I say that, look where it is. It's all the way in the back. There's going to be a sign that says no parking, and those people are going to park back there. And it won't be enforceable because nobody will know they parked back there until there's a fire and you need to get a truck turned around.
What I would like to say is that we'll talk to him about whatever makes him happy. I think that's,
But just something that either guarantees that people won't park back there, or it's big enough in case they do, that it still works.
Yeah, I have a follow-up on that for Mary. Can we enforce private road no parking?
Yes.
Well, that's not the point. Nobody's going to know it unless a neighbor reports it, and no neighbors back there are going to report it because they're going to want to use it.
yeah, I'm wondering, no matter how big we make it, and then 4 people could park, and we might have the same problem.
I hear what you're saying. There's a limit.
Yeah.
But just something to
about-
accommodate that, because we know that somebody's going to park there.
What if, Greg just brought up a phone, what about a ballard?
You put
The
those poles
Ballard.
right in the middle, you put a lock on the pole, nobody can get through, nobody can park in or out of there, but the fire department has a key to the lock. They unlock the house and then they have access.
Yeah, that might be the way to go. That way no one could park even if they wanted
Right.
to.
Right.
Yeah.
And that's the deterrent you're
What
looking
we
for.
That
do
makes-
for there's access trails that we have,
Yeah,
not bringing
yeah.
up trails now, but access trails that we have now, where we have a pole in the middle of it, and if the police or fire need to get through there, they unlock the lock and the pole comes
Yeah.
out, they drive right through.
Yeah, we should do that. Yeah, that's a good idea. We can do that. Is that okay? Okay.
Just a question, is that also the turnaround for school buses and trash trucks, or are we assuming they're going to make all the stops on Whitmer?
Right now, I mean, we really haven't gotten that far because we haven't had anyone talk about the actual development. I envision them going along Whitmer and stopping there, not coming down this private road with a bus or a trash truck.
I think those kids walk down the lane.
Yeah, I think they can make it.
It's just a matter of who has keys for the bollard locking.
Well, I guess the other point is that the fire trucks are not going to be, like, I don't know, can an Amazon truck get through there
Yes,
Okay.
yeah.
and do the turnaround?
We might point out that, is this on?
Yeah, you just got to get close to
Just gotta
it.
get closer.
That the fire marshal was actually requiring an 18-foot cartway with 4 feet on either side. And as Kristen did mention, we're going for a 20-foot cartway with 5 feet on each side. So we're, in respect to a lot of the questions, I think we're trying to address that possibility.
So you good? Everybody good?
Council's happy, I got it.
Mary, as this moves forward, with going back to the no parking signs and enforce, do we have to adopt a separate ordinance to add these?
No, that'll be part of their homeowner association restrictions.
So if someone calls the police and tells them there's cars back
It won't be
there,
enforceable by the police, it'll be enforceable as a homeowners association requirement. And we'll have the ability to enforce under the homeowners association agreement.
Okay.
If you choose as manager to send the police out for that, that's fine. It could also be done by code enforcement if you find that people are parking in there and it's not available for the fire company.
okay.
We're good.
Okay, great.
And that's preliminary final?
Yes.
All right, thank
luck.
you.
Okay, thanks.
Appreciate it. Have a good night.
Next is zoning hearing board applications. First one is Kristen Devlin on Fair Oaks.
So this application on Fair Oaks, what they would like to do is remove 174 square feet of existing patio and construct a 672 square foot two-story addition to the existing single-family dwelling. This is in our R4 zoning district, so for them to be able to do this, they need 3 variances. The first is for building coverage, impervious coverage. So they have a coverage right now, 17.6% currently exist. A maximum of 20% is allowed. By this, they would go up to 20.7. Front yard, they're just coming into compliance, so their front yard, a minimum of 50 feet is required. Their current front yard is 33.5. It remains at 33.5 for this project. And their final one is the side yard. They're allowed 10 feet and 25 feet. They currently have 12.5 feet and 25 feet. They would go to 7 feet and 19.5 feet for the addition.
It's pretty de minimis.
Yeah, it's in one of our older neighborhoods. Staff's recommendation is that you look at it as neutral. We think it's an improvement to the property and to the neighborhood.
Okay, everybody okay with that? Okay, we'll go neutral on that one. Next is Thomas Kustrin at County Line Road.
So this application is one that you've seen recently. We've had 2 others in the recent past, and it comes off of a year ago of what happened to our township with the tornado and flooding. So this property is located on County Line Road. This is County Line Road, and then the property's right here. There's a Horsham Water and Sewer Authority pump station right here. The Hankin property's behind it. And what they're trying to do is, what they want to do is demolish a portion of the house and add a second story, which will be their primary living area. This house gets heavily impacted. There's a tributary that comes through the Hankin property and crosses County Line Road at this point and travels into Warminster Township. So it's in the floodplain. Our floodplain ordinance does not allow alterations of this type on structures that are in the floodplain. So you just had 2 recent ones in the last couple months, one right here on Horsham Road, one on Davis Grove Road, and these people are doing the same thing. So they hope to be able to live in their homes and their belongings do not get destroyed in any future floods.
Your recommendation is neutral?
Yes, sir.
Everybody okay with that? Yep. Okay. Last but not least, we have the Devco on Eastern Road.
This is on 1250 Eastern Road. Many of you familiar with the Dunkin' Donuts. This is Dunkin' Donuts. This is 1250 Eastern Road, where the hoops are played. And what they want to do is an off-premise sign right past Dunkin' Donuts on Easton Road. And I will turn it over to them to, as council knows, off-premise signs and LED signs, either by special exception or variances are needed at this location.
Good evening, everyone. Amy Farrell with Kaplan Stewart. We are the attorneys for the applicants here. As was just mentioned, and as this board is aware, there is a zoning application pending for this location for a special exception that's related to a 200 square foot single-sided billboard along Easton Road. The sign as proposed meets all of the bulk and dimensional requirements of the ordinance that would entitle it to a special exception, and as such, the applicant is prepared to go forward with that sign application before the board in September. However, following submission of the application, we had an opportunity to meet and discuss with township staff the proposed sign, and we had discussions about whether we could look at any alternatives that would improve the aesthetic quality of that sign. There is a side-by-side, Bill, if you could go to, there's a sort of simple line drawing, I think that might be the easier one to start with. Nope, it's a separate slide.
Separate one?
Yep.
Hold on.
Sorry, I'm making this as complicated as possible.
Especially with me and technology. Let's see, survey.
There we go, that's it. So you can see on the left-hand side of this drawing is the sign as it's currently proposed and as pending before the zoning board. It's an 200 square foot single-sided sign face with brick piers, 25 feet high, and again, it does meet all of the bulk and dimensional requirements of the ordinance. On the right-hand side, we took a look at what we could do if we bulked up those piers a bit, did a little different treatment with respect to the finish of those piers. It's a stone proposed similar to the stone behind you on your wall. Added, obviously, some additional amenity language for the township itself. This sign would be a double-sided sign. It would be a V shape, less than 45 degrees. And the sign face on each of the sides would get a bit larger, as you can see here. So the sign gets a little shorter. It's 23 feet rather than 25 feet to the top of the sign. But it does, the size of the sign itself in terms of the sign face does increase to 288 square feet per sign face rather than one single 200 square foot sign. That does trigger variance relief related to a sign such as this, and there's three sort of primary components. One is that the sign does get a bit closer to the roadway by a few feet, and that's because there is an existing easement on this site that prohibits us going any further into the site. So by dropping the sign a bit to 23 feet, it does get a little wider when we strengthen up those piers. So it comes a couple feet closer to the roadway. So the edge of the structure would be 22 feet from the road rather than 25 feet from the road. And then, of course, as I said, the biggest change I think that the board will recognize is that the sign faces themselves do get larger, which would require variance relief because your ordinance limits a sign at this location to 200 square feet total. And you count both sign faces towards that total, even if it is double-sided. So again, we're comfortable with the one on the left and prepared to move forward with that. We did want to come in prior to going to the zoning hearing board to discuss the alternative option on the right to see if that was something that was more interesting to the board. And if so, we certainly would consider pursuing that one as the alternative sign option here. But really up to your discretion and your interest in whether or not that's a sign that you would be interested in us taking a look at. And I do have with me this evening Patrick Wolfington and Tim Earl, both with the developer, happy certainly to answer any other questions that you may have about the sign itself specifically. We did, and Bill I think had them up earlier, renderings to help sort of give you a sense of what the difference is. If you could start at the top there. There we go. So this is the sign as it's currently proposed, single-sided, looking northbound. Again, those are the brick piers with the required landscaping. That sign does comply with the 200 square foot size requirement. It complies with the height requirement, and it complies with setback requirements. Next slide. This is the difference in that sign if we were to drop it down slightly, widen it a bit to increase the sign face and to bulk up those piers. And again, this moves a couple of feet closer to the cartway edge.
Why does changing the shape of it move it closer to the road?
So there's a site plan, we can help explain that in a bit more detail. There is an existing easement on the property that is inbound of the cartway edge. So we can't encroach into that easement. So by dropping the height of the sign, making it a little bit wider when we add those thicker piers, it gets a little closer to the roadway. So the sign is wider in the alternative proposal than in the...
I understand
the sign being wider. I'm still struggling with why the front edge of the sign has to move closer to the road.
Because the rear edge of the sign can't get any closer into the site because of the existing easement. So that back edge of the sign has to stay where it is.
Isn't the whole sign in an easement then?
No.
What the heck? What easement is behind the sign?
Sure. If you can see, and
Water,
Tim can
sewer
explain this
easement.
more. If you see the V, sort of there we go, right there. just behind that, you can see the double line right where the cursor is right now. That's a 20-foot wide water and sewer easement that runs along the entire frontage of the property. So the back edge of that sign can't get any closer into the property than it is currently. We have to set that line and come out closer to the roadway.
Okay.
It's also with the pillars extending on either side.
Right, so that's why the sign gets wider, is if you go back to either the rendering or the side-by-side, your choice. There we go. And you can see those pillars are wider than the brick piers. So the whole width of that sign gets a bit wider.
Oh, I understand that you made the sign wider. I didn't understand the easement in the back.
Right, got it.
I understand.
I'm struggling with, the one you can do by right or by zoning is 200 square feet, and you're almost tripling the size of the sign, so that you can do what? So that we get a prettier sign?
Yes, I mean, coming along with the effort to increase the piers, increase the aesthetics of it, change the material, et cetera, there's costs associated with doing that. And so it starts to become difficult to offset that from a developer's
There's
perspective.
certainly a significant benefit that comes to the sign manufacturer to be able to have a double-sided sign as opposed to a single-sided sign, in terms of revenue and everything else, right?
Correct.
I think you want to have a double-sided sign instead of a single-sided sign.
Yes, so, and again, we acknowledge that. So, as soon as you get to, because of the way that your ordinance reads, because typically in these situations, in most municipalities, I think the way that your ordinance read before it was amended, each sign face was not counted, right? You count one sign face as long as the other one is either parallel or less than 45 degrees, you're only counting it once. So you would get 200 square feet of sign face on one side, 200 square feet on the other. Your ordinance requires that both sign faces be counted towards that total maximum. So if you were going to do a double-sided sign here, 100 square feet maximum on each side is what you would get. And I think you would hear from the developers that that's not a sign that the average advertiser is interested in.
Bill, do we have an aerial of that again? Where that's located?
Yeah.
Yeah. Eden?
Exactly.
In front of Eden?
I just pulled this off Google Maps, but it would be, and correct me if I'm wrong, it would be right about here.
Are there trees that have to come down to build this?
Yes, there are trees that come down in either scenario.
Does that fall under our tree ordinance, Bill? Land development?
Well, no, it's not land development, but they do has replacement trees scheduled to replace the trees. They're not, they're replacement trees, but they're not going to be as
And I'm
mature
familiar-
as the trees.
Right. I'm familiar with the area. It seems like it's heavily wooded there.
So it's a few trees along the street frontage that do have to come out under either scenario. Your ordinance does also require, as part of the billboard development, irrespective of the trees that are coming out to be replaced, that certain trees and shrubs be planted. Those will be planted as part of it as well.
So as I look at the overhead, the one that says Horsham Township is a sign with angles less than 45 degrees. And then when I look at the overhead of the cheaper option, it's one.
It's one,
But
correct.
one side is bladed away from traffic. It looks like the right side, as you are heading northbound, is the angle which you are hitting people. So it seems like you are getting additional benefits if you do that double-sided sign, back to Mr. Nesbitt's point.
Oh, and we acknowledge that. There certainly are benefits.
Like that,
from
you're not going to get, if you go up one, please?
Right, what you're going to see in the single-sided is the back of that sign, correct?
And you're not
There's
really
no-
going to see that coming around that corner. So it seems if we do the double-sided sign, that is like the, instead of 288 feet, now you have an opportunity to view the sign from both sides.
From both sides, yes, that would be the intention, is that you would be able to see that sign from both sides versus seeing only the primary in the single-sided sign. from that, with the single-sided one, coming from the opposite direction, you're just seeing a part of the back of the sign. You're not seeing any signage.
Right, so I'm just struggling to understand that extra 88 feet. So it's like, to me, the ability to see it the other direction makes up more than, you're able to have another side of that vice, the other plan that you're offering. I just don't understand the difference in the size dimensions.
So, and I'm gonna ask them if they want to come on up and give any other, understanding or give you any more color as to why it gets to be the size that it is. But typically, it has to do with, as I said earlier, as soon as you start spending more money on all of the aesthetics of this kind of a sign, you do start to sink costs into it, and so you need to be able to recoup those costs, obviously, as the developer. So that starts to drive the signage.
But from the township's perspective, their review of this can't concern itself with the financial impact on the developer.
Understood, and we certainly wouldn't be asking you to, and we realize that from a variance perspective, that's not a factor. But it is a factor that goes into their analysis as to whether or not it's justifiable from their perspective to do the extra work, take the extra step, do the increased, improved aesthetics. That all becomes part and parcel of the analysis that they have to make. It's not a justification for a variance standard. We're not suggesting that it is. What I am suggesting is that in order for them to take that step and go through the process of expending the additional funds to do the additional work to make it more pleasing, it has to work for them from a balanced development perspective. And that's where you land at the size that you land at.
Well, I'll give you my opinion is, given the location of the sign, where it's located with the number of trees that are there and whatnot, I'm fine with the single sign. I don't think a double sign is necessary.
I can tell you, like, I would never want Horsham Township Community Connected on a billboard sign. I don't, like, that's not our branding. Like, we got enough.
You're not sponsoring the sign?
No, that's what it looks like. It looks like, oh, look, Horsham Township just put up a sign and now we're advertising. So I can tell you, you wouldn't even have to incur that cost if everybody else was like-minded with me. I'm with Mr. McCouch. If my choice is between a single-sided 200 square foot sign versus 3 times that size for better stone and more green space, to me, that's an easy trade-off. I'm fine with the single-sided sign.
Well, I still have a question about the trees.
I'm not fine with it, but if that's what you say is right, that it meets all the zoning requirements, then.
Are you proposing to remove trees in order to construct the sign or to view the sign?
So under the single-sided approach, there are 3 trees that come out along the street frontage in order to be able to, I believe it's to view the sign, correct? It's for the view shed of the sign.
Do we have to allow them to cut trees down to view this sign?
I think, I'm sorry, Jim, but I know that Eric issued an opinion letter. The trees that they're taking down were street trees from a previous land development at 1250. And I believe, Amy, you're relocating those street trees to another location?
I believe that's correct. Those trees are being replaced. And then in addition to that, there are trees that are required as part of the billboard.
That the street trees got too tall for them to be able to see the sign behind the street trees. So they're removing the street trees in order to make the sign, we're removing and replacing the street trees in order to make the sign visible.
But why do we have to allow trees to be removed to make it more visible? I understand why we need to let them remove trees to construct it, but not to look at it.
And that's where I'm gonna, hello, Jim.
Hello, Mary. So, we point out in our review letter that the street trees that have to be removed were part of a prior land development approval. As far as the enforcement of that prior land development approval, I'm going to kick it back to you.
Kick it back to me. I would opine that you can't do that without amending the prior land development plan. So the prior land development plan shows trees at XYZ location. Those trees were planted, escrowed for and planted, and now they're going to be removed. I'm not sure how you do that without amending the land development plan that required them.
I hear what you're saying. I'm just taking notes, sorry. Well, I don't want to get into whether or not that's the appropriate standard here. I think that first of all, what's before this board is only the question as to the zoning application that's coming up next. The zoning application does not require that those trees be removed. It's not proposed as part of the zoning because the zoning application and the zoning ordinance don't cover street trees, right? So the question as to whether or not those street trees can come out, have to come out, whether you have to require that or not, I think is not a question with respect to the zoning application itself. Because the zoning application, as long as we show under the zoning application that we're meeting the landscaping requirements that are specific to zoning, which we do, then that's the only question that's before the zoning hearing board as far as the special exception goes. Whether or not there's a requirement to amend a land development plan simply to relocate a few trees, I think we'd have to look at what historically is done in that context in any kind of land development that exists in every township. I mean, it happens. Street trees die, street trees get relocated for one reason or another. View sheds change, signage is relocated. Those things happen all the time. Generally, as long as you are providing for the trees that you're replacing, then you're entitled to do that as a property owner who's developing their property. I think you can't, on one hand, allow for the use, and then on the other hand, in such a way, prohibit any modification to make it functionally obsolete. I think that's pretty disingenuous.
Are the trees being replaced in the exact location?
No, I don't believe so.
Then it is a change in an approved plan that's been recorded. And I would just wonder, wouldn't you rather deal with this issue now than go to the zoning hearing board, get whatever special exception you're applying for, because you're only applying for a special exception and you're only looking at the zoning ordinance requirements, and then have your zoning permit denied because I think there's a provision in the MPC that that allows you to deny a zoning application if there's a violation of the subdivision and land development ordinance?
Right, but what I'm saying is, I'm not sure how you want to resolve it now. I think because Mr. Whiteside's question is, well, do we have to allow them to take the trees down? I don't think that's a question that's actually before you under the context of the zoning application. The zoning application is simply...
When would that question be before council? If it's not before them tonight...
That was my question next. If this isn't the opportunity, when is the opportunity?
Well, I think to Mary's point, that's then part of the zoning permitting process, right? So it is a multi-step process. What the zoning hearing board is being asked to determine is whether or not we qualify for a special exception. And the special exception standard is very clear. There are specific objective criteria in the ordinance. You either meet them or you don't. If you meet them, you're entitled to that special exception. The zoning ordinance does not say anything about the street trees that are on the site in connection with an existing previously approved and recorded land development plan. So the zoning hearing board can't reach the question that you're asking. I'm not suggesting it's not a fair question. I'm just saying it's not a question that's before the zoning hearing board at this point. So I think the zoning hearing board considers the application on the four corners of the application and the ordinance, either grants the special exception or it denies it. If it grants the special exception and we submit a zoning plan that shows trees coming out and there's a determination made at that point that those trees can't come out for one reason or another because of saldo, then I think that's when it comes up before you. It's either an appeal of that determination or an application to this board for land development modification. But it's not part of the application that's before the zoning hearing board at this point.
Yeah, that's a whole lot of running in place to try and answer this question. And I'm just wondering if it wouldn't be better for your client to continue the zoning hearing board application till we can get a definite answer to the question that Mr. Whiteside asked. Because I think this is something like we've talked about from our first meeting
with the applicants. You're removing trees that are shown as required on an approved subdivision plan. How is that not a violation of the subdivision plan? And at bare minimum, I would recommend to council, if that's something that concerns them, and if the replacement trees are not satisfactory, that should be brought to the zoning hearing board's attention so that they can know that the plan in front of them the special exception is going to be in violation of the subdivision and land development ordinance.
Well, again, the special exception is not in violation of subdivision and land development ordinance. There may be a request for an amendment to the land development application, but one doesn't automatically preclude the other. You either meet the zoning requirements or you don't. There's separate subdivision and land development requirements that you either meet or you don't. There's a lot of case law out there that says, and it's recent case law from the Commonwealth Court, you cannot incorporate subdivision and land development provisions into the zoning ordinance and preclude zoning for future land development approvals.
That's not what we're trying to do here. That's not what we're trying to do here. You have an approved and recorded subdivision plan that you are altering without the approval of council. Now, the question becomes, what zoning relief can be granted when you're failing to complete the requirements under the subdivision and land development ordinance? And I believe, and I'm trying to pull it up now, but I'm not doing it quickly, unfortunately. There is a provision in the MPC that specifically says that when you're in violation of a subdivision and land development ordinance, zoning relief can be denied. And I think that since the question's been raised, it's appropriate that we get an answer for it before it goes to the zoning hearing board.
And I think you're mixing and folding everything into a single application. There's nothing in the zoning application that triggers those street trees.
Certainly, there's time before you go to the zoning hearing board for me to look this up and get a letter to the zoning hearing board opposing it. This is your only shot to be in front of council. So I'm just wondering if that's the way you want to handle it.
We're not, this application was filed, I think, in January, right? And has been continued multiple times while we've tried to work through some of these issues. We will move forward in September. I know, I think he's on my side, Mary. I think he's on my side. We will be moving forward. We cannot continue this
So, Mary,
application
would it be
one more time.
appropriate for us to oppose this at this time to the zoning hearing board with the basis that you've spoken about and follow up with a letter to the zoning hearing board stating our case as to why we'd be opposing it?
That's all I can offer you tonight. I'm sorry.
Well, the other thing I don't understand, I need clarification on is they're showing us two different options.
Well, to be clear, we would not be moving forward with the two-sided option unless there was indication from council that you were interested in that one. So the only
Have you got a
application,
clear indication that the majority is 200?
so the only application that will be before the zoning board is the one that already
Yes.
exists. We're not looking at the two-sided one at that point.
So absent a clarification on the removal of the trees per the prior land development, would you do a letter in opposition based on that position, Mary? Is that what you're proposing?
Pending clarification of what the MPC permits.
And I'm in favor of that.
The other option is just postpone your zoning hearing board, which you're not want to
We
do.
understood, but we're just not in a position to do that at this point. That application was filed in January. It's been continued multiple times. I don't think that, quite frankly, the street trees are a component of the zoning application that the zoning hearing board can reasonably consider as part of the application. We'll take a look at whether there's an alternative solution there, but I don't think it's appropriate to continue that hearing on that ground.
That's fine, that's your choice. Mary, if we oppose this and we go with a letter to the zoning hearing board stating our opposition because of the violation of the previous land development, what would happen, I'm just trying to think ahead, if the zoning hearing board says, well, we're only going to vote on whatever's in front of us, and they approve the application, what direction we would go from
The
that?
township always is standing to appeal if they choose to do that, whether you appear in person or not. So you have.
We still have
You have a lot of
another-
time to make that decision.
I do have another question, though, maybe moot at this point. The two signs were two different heights.
Yes.
Why was the double-sided sign so much lower than the other one?
I think it was only lower by a couple of feet, and that was to the top of the sign. The piers themselves are a bit above that as well, so part of that is making sure you're still holding to that 25 feet overall to the top of the pier. And then sometimes as you change the size of that sign, the ratios change slightly, because there are certain industry standards for the rectangle that you want it to be. So that sometimes moves it up and down by a bit.
So is everybody, go ahead, Bill.
One more thing, unrelated to trees. As you move forward to the zoning hearing board, there's two other decisions and orders of 1250 Easton Road. And there's the landscaping company behind. That has to be in compliance. If they're not, that might be raised at the zoning hearing board. So hopefully, I know the property owner was trying to get the landscape company into compliance with a past decision and order of the zoning hearing board and the conditions of that decision. I don't know if that's happened yet or not.
And I don't either. We're the
But that's-
tenant there, so we're not aware of it. Oh, actually, it sounds like we might know.
It has?
Yeah.
Okay.
Sounds like it has been cleared up.
So is everybody okay with the opposition with the letter? So we'll go in opposition and we'll take it from there.
Okay, thank you.
Good luck. Hey, if there's no other items to discuss, then this meeting is adjourned.